I object to you getting records. You've been intrusive into people's personal lives. You're confused. You think I'm on trial.
Mr. Bond Jr., quite frankly, is the one who has the information.
I have issue with your question, so let me break that down, okay? Let's be clear. Man, I can't speak to that. I don't have information to that. I cannot speak to that. Let me deviate.
Objection, Your Honor.
I cannot speak to that. I do not know. I don't know. I don't know what you're asking me. I cannot answer that question. Is that clear? I don't know. I cannot answer that question.
Objection, Your Honor.
Right? So I want to be clear. I don't know. I cannot answer that question. I know something. I think you and I can agree on that. I think you and I can agree. You and I can agree. Show me.
Okay.
I cannot answer that question. Was not. Let me be very clear, and I need to be very clear. We agree, right? But what I need to be clear, I assumed, I want to be very clear. So let me make sure I'm clear. This is me. Your response, your acts is not reasonably calculated to put me, the business record custodian, in a position to know what you're talking about.
He is the best witness. He is, quite frankly, the only witness that can really testify to the mechanisms that we have in place within the office.
At that time, I did not know what analytics graphs were. I didn't know what you were talking about.
Let's go ahead and get started.
Great. Okay, so we would call Dexter Bond into the stand. We would invoke the rule of sequestration.
Okay. So the rule of sequestration has been invoked. That means that anyone who is expected to be called on as a witness, I see that Ms. Miller is stepping outside.
Judge, I think this could make things faster. The county or the defendants indicated that in some of our conversations about that they may be willing to stipulate that our open records were received and that they were not responded to within 3 days, according to statute. If that's the case, I can remove a lot of my questions. But if the court wants that testimony, then I think the question is when they were complied with, but I don't think anybody's arguing they were complied with within 3 days. So if that's the case, I can remove a lot of my questions.
Ms. Monroe or Mr. Bowman, who am I going to hear from relative to this witness?
From me. So what I did say that I was going to stipulate to is that the information wasn't provided initially, but as far as the 3-day window, I would have to double check because there are several requests before Your Honor. So I'd have to double check which ones in fact were not responded to within 3 days. So I can't make that confirmation. If I just have like 2 minutes to check my notes to see which ones were actually compliant.
I think that is time well spent because that 2 minutes might save us 30 minutes. So if you will take a moment to do that, that would be much appreciated, Ms. Monroe.
Thank you.
And regarding as a moment ago, I was talking about the rule of sequestration. Just right now, it looks like we're only going to be having Mr. Bond and Ms. Miller as an initial matter, but I just always ask, y'all know who your witnesses are and what they look like way better than I do. So if somebody wanders in, please keep an eye out. Also, that applies, I'm sure I don't need to say this, but it bears repeating to anybody that might be watching on the Zoom or on the live stream. If you anticipate that you might be called as a witness in this matter, you should not be observing these proceedings. Thank you. I'll tell you what, since Ms. Monroe, since Mr. Bond is here, if you'll continue to keep looking, but also let Ms. Monroe see if she can at least start with some of the preliminaries. And it may be that even I'm sorry, Ms. Merchant, it may be even that Mr. Bond can confirm what you're trying to confirm. I appreciate the effort, but just in the interest of time.
Yeah, of course.
Mr. Bond?
Yes.
If you'll do me a favor and raise your right hand, I'll swear you in. Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, thank you, sir. You may lower your hand. Please state and spell your name for the record, and then I will deliver it over to Ms. Merchant to begin her questioning.
My name is Dexter Q. Bond Jr., Dexter, middle initial Q, Bond. I am a junior.
Great. Thank you so much, Mr. Bond. Can you tell us what your job title is?
I am the Deputy of Operations for the Office of Fulton County District Attorney's Office.
Does that include being the records custodian?
Yes, among many things.
Okay. And before we get into the documents, I want to talk to you a little bit about the portal, how that's set up. If first, let's talk about at the time that I made the request in January of 2024, was there a website link on the DA's website for open records at that point in time?
In January, yes, there was a link on our website. Yes.
And when a person clicked on the link on your website, it took them to the county attorney's open records portal, correct?
Yes.
And there was a drop-down box if they went to that open records portal to request records from the district attorney's office?
And I can't speak to that because
Okay.
I don't request records from the district attorney's office.
Okay. So at some point in time from then till now, was that landing page from the DA's office website removed?
I don't have information to that. I don't know.
Do you know if the open records page, the page that the public would go to, if that link was ever altered?
Are we talking from, give me a time frame.
From January until now. So what we just talked about was in January. If I went into the DA's office website, I clicked on open records, it took me to the portal.
Yes.
A month ago, if I went on the DA's website, clicked, and there was no open records link at that point.
I cannot speak to that. I do not monitor that site on a daily basis. I do a lot of things for the office, but that is not one.
Okay, so you cannot speak to whether or not there was an open records portal site or portal link on the DA's website.
No, I answered that question. There is an open records link on the DA's website. You will click the link. You can go into the portal. You can request open records requests as you do often.
So there was one in January and there is one now, right?
To my knowledge, yes.
Do you know if it was removed at any time over the last 9 months? And
I cannot speak to that.
okay, thank you. Who could?
I don't know.
So Dexter Bond doesn't know who the IT guy is. I guess when his computer crashes or something happens, he don't know who to call. Well, let's do a who is on the Fulton County's webpage and see what it reveals. So we're running a who is on GoDaddy. You can do this. It doesn't cost anything. If you ever want to know who's behind the website, you can get some good information from this. However, they pay for domain name protection privacy, so there's not a whole heck of a lot here. However, there is one single email to Terrence Slayton at Fulton County GA. Who is Terrence Slayton? Let's go see if he's listed in the departments on the Fulton County District Attorney's webpage. And let's go under for information technology. Oh man, guess what? No Terrence over here. Not even in the email address. That email address is technical support at Fulton County GA. That's who that goes to. There is no mention of Terrence Slayton anywhere on the district attorney's webpage. Nowhere. Nowhere to be heard, nowhere to be seen. But who is Terrence Slayton? Well, let's go take a look. This is Terrence Slayton, Chief Information Security Officer at Fulton County Government. He has been with the Fulton County Government for 18 years, but Dexter Bond doesn't know who he is. So how can we establish a connection between Terrence Slayton and Dexter Bond and see if they actually do know each other? I'm not going to submit a request on revisions on the website or anything like that. I may do that later. Right now, I just want to know if they know each other. So I put a request in for all emails between Terrence Slayton and Dexter Bond between January 1st, 2024 to October 1st, 2024. Here's what I'm expecting. One of two things here. I'm expecting a lot of emails with an excessive amount of fees associated with the request. Or two, there's nothing. I find that hard to believe because Dexter has been there for a while as well. 3 years. How could he not know who Terrence Slayton is? That's wild to me. Hopefully we'll get those requests back while I'm doing this video. But we are fact checking. That is the nature of this video. I'm fact checking everything as we go through, finding all of their little wiggle room holes that they try to sneak out of. You've already heard the defense sandbag and talk about they didn't want to release the records because they were scared of what somebody might do with them. You can't do that. That's a violation of the Open Records Act. It could also potentially be a civil rights violation under the First Amendment, freedom of the press. You can't do that. There is no stipulation in the Georgia Open Records Act that anyone has to provide information about why they want the records. It's not necessary. You can make a request anonymously, just like I just did. I want the emails. There's nothing else needs to be said. They just need to comply. But anyway, let me quit yapping. Let's get back into it.
I don't maintain that particular website. Once the information is placed in the portal, if necessary, it'll be elevated to me, and I do my job as the business records custodian. But as it relates to it sounds like, forgive me if I'm wrong, but I'm interpreting your question to be a little bit more, I don't know what you're asking me, but I can't.
How the public asks you for open records.
And I'm saying that the DA's office has a website. As you know, the DA office has a link that you can use. The DA's has once you click that link, it goes to a portal, which we have used several times. And once you go into the portal, you can put in your request. That's what I'm saying.
Are you able to testify if over the last 10 months that process has been in place?
I don't object just based on the fact that the availability of the link in the portal is not an issue in this case, and it's not an issue pertinent to whether the records were provided timely.
Ms. Merchant, is there a reason, is what you're really trying to get to that for the entirety of the last 10 months, Mr. Bond or someone else would be tasked with and subject to complying with open records? Or are you really trying to ask if there's an actual portal button on that website for the whole last 10 months?
I'm trying to figure out if they've had, so once I made my request in January, I had to make follow-up requests and it went away. And I wasn't able to continue to make those follow-up requests, which is part of what, when we continue to make those requests.
Okay.
Forgive me, I'm gonna reframe your question and you make sure that I'm not reframing it appropriately, right? Your time frame at issue is from January to the present.
Yes.
And you are asking me at any time, did that particular process deviate?
Yes.
The answer is yes.
Okay.
May I explain?
Please.
Because of the cyber attack. I do know, if I'm familiar, that you received the open records request saying that, hey, we are under a cyber attack.
With the risk assessment process, the part that was surprising was the law.
But wait a minute. Play this from the beginning. And let's go ahead and document this too, by the way. I've already copied the link and everything else. This is Terrence Slayton and the Fulton County government was surprised when a data risk assessment showed the plethora of sensitive information that the entire organization had access to. This was back in November. They said they had a cyber attack in January. The merchants put their request in January, but this guy is not saying anything about a cyber attack. Let's watch.
Large amount of data that we found that contained sensitive information that the entire department had access. From there, we were able to find all the files that, because of broken permissions, had the everyone access to it. That was within the first 30 days of us having Broadens in-house. So from there, it's just been an eye-opening process as we've tightened down rules, but we were able to identify this quickly and remediate it.
So Varonis is a security company that does audits with the government. This created a government contract, so there should be some records available for this. I'm not gonna put those in now, but what I do want to point out is everything he just said are internal issues. They're permission issues with users on the network. It's their internal issue. They didn't say anything about a ransomware attack or anything. And this is around the same time. So it's safe to assume that in November, this security company had a lockdown on that network.
I'll provide a brief update on our cyber event restoration effort. In terms of IT update or cyber event update, a lot of this information is already out in the public, but just to reiterate where we are. First and foremost, we continue to remediate the damage that was done to our systems. Telephony access is now fully restored. I'm proud to report that, and we continue to test that system. It does have some variability to it, and we're looking at both the provider as well as the network in terms of that, but it has been fully restored. For example, public access is now available to Fulton County court records through Research Georgia. This site includes many publicly available filings for Superior, State, Magistrate, and Probate Court. And if users do not have a Research Georgia account, they will need to create one. Some filings that were made prior to the incident in late January may not appear at this time while restoration continues. For more information, the public should contact the respective court with which they are interacting. I also want to speak specifically to third-party background checks, which have been in the news. Background checks conducted by Fulton County Sheriff's Office or Fulton County Police Office were not affected by the recent cybersecurity incident and have been continuously available. We do have now very detailed plans at both the department, the service level, and the system level that have been supported with a PMO, or project management office, that we've established that is also being assisted by Ernst & Young. So, Mr. Chairman, that concludes our report on the restoration effort.
Nowhere in his entire interview, and I'll leave a link below in the description, but nowhere in his entire speech did he say anything about cyberattack. It doesn't seem like it makes any sense, but then again, we'll have to do some open records to find that out, won't we? Now we know where to look. And be sure to let me know what you think in the comments of all this nonsense. Now let's get back into it.
This will require a delay, and I do know that this portal is not maintained by my particular office, right? I think you and I can agree with that they made some modifications. So if your question is, look at 10 months, did something change from the routine? The answer is yes. The reason why is because it was a cyber attack.
I'm just going to interject very briefly. You're like me, you're naturally a fast talker. And for the benefit of the court reporter, she's already asked us once to slow down. So if you'll try to be real conscious about speaking slowly so she can take it down. Okay.
Yes, Your Honor.
Thank you, sir. Go ahead, Ms. Merchant.
And I just want to make sure I understand. So it changed because of the cyber attack. So that portal link was at some point disabled or not available?
So you asked me, did something change? I reframed the question to make sure that we were on the same page, right? I told you, yes, something did change. I gave you an answer as to why that did change, and that was as it relates to the cyber attack. Again, the framing of your question was from January to the present for the last 10 months, right? And enter in your question, you asked me something about the last 10 days. So forgive me.
10 months, I'm sorry.
You said 10 months, but you also said 10 days. I asked you a follow-up as it relates to the framing, right? I've answered that question from January to the present. I have told you that the reason why that has changed is because of the cyber attack. I've also told you that I do not maintain that website on a daily basis.
My question was, how has it changed? You said it's changed. My question is, how has it changed?
I cannot answer that question. What I can say is that from 2021 to the present, the DA's office has had access that allow constituents like yourself to request open records. That link is displayed on our website. Once you click that link, you can go into the county's portal. I've also told you that I do not monitor that website on a daily basis. So if you're asking me how, I cannot answer that question. But if you telling me for look at the last 10 months, if it has changed, I am telling you a cyber attack has required a lot of things, including open records, to change.
Mr. Bond Jr., quite frankly, is the one who has the information. He's the one who has the knowledge of how open records work within the office. He is the best witness. He is, quite frankly, the only witness that can really testify to the mechanisms that we have in place within the office in order to ensure that individuals that reach out to us and wish to receive open records receive them. He will testify.
Okay.
Yeah.
Thank you, Ms. Alavi.
Thank you, ma'am. Appreciate it.
Do you monitor the open records portal?
Do I monitor it on a daily basis? No.
Do you monitor it at all?
Yes.
How often do you monitor it?
On an as-needed basis.
As needed. Okay.
Yes.
How do requests come to you?
You go to the link, You put it in, it goes into the portal.
Sorry, and just to save time, I'm not asking how I do it. I'm asking how they come to you.
Once a staff member on my staff, a designated staff member for open records request, receive the open records. If it's standard, like the many of you have supplied, we can go ahead and give you a responsive record, right? If it's not standard and it requires an elevation of some sort, then it is elevated to me by a staff member.
Elevated to you?
Elevated to me by
Okay.
a staff member.
So the first sort of triage is the staff member reviews it, determines if they can just answer it quickly.
I would say that, yes.
And then if it's something that's more elevated, can you describe what something more elevated would be?
I'll do it the opposite way if I can. If you're looking for an invoice, a particular invoice, and that invoice has been commonly requested, my staff knows that this is a particular invoice. And for efficiency purposes, we'll get that responsive document to you as quickly as possible. And then if you're talking about something that is exempt or possibly exempt, that's an example of something that's going to be elevated. And not in this particular case, but in some cases, my exemptions include open and active investigations. So in those particular cases, that'll be elevated.
Were my requests elevated?
You have to be more specific. You know, you gave me about 40.
Were any of my requests elevated?
Yes, ma'am.
Were any of my requests not elevated? You can narrow it down.
I'm going to say yes, because 40 was not presented to me. I know that you are a frequent open records requester. I know that we have responded to open records requests. I am familiar that you, I would say dozens, and I would not say that all dozens have been presented to me. Those have been closed out based on my monitoring. So I am comfortable saying that all have not been elevated to me.
And you said I did 40 open records requests?
I said dozens, maybe 40. You have to be more specific. You know, you gave me about 40. I feel comfortable saying dozens. I know.
They're maintained on the open records portal, though, right?
Yes, I'm pretty sure they are. So maybe 40, maybe 30, but I know it's a lot.
Would it surprise you that it was less than 12?
Oh yeah, I think I'll be surprised by that.
Okay, and let's go through them in a minute. We'll go through the specifics. But
May I ask a follow-up? 12 an issue or 12 a total?
in total,
Since when? January to the present?
since Ms. Willis was DA.
That would surprise me. That would surprise me.
You all have a employee manual that you use at your office, right?
Yes,
Okay, and that governs, it also talks about open records requests.
I believe so. Yes.
And if you want to look, we've got, these have been admitted previously. This is merchant 0602. I believe the county attorney supplied this, I'm assuming from your office. Does that look like, you can look at it on your screen, part of the employee handbook that's given to new hires that Ms. Willis created or updated?
Mr. Bond's eyes may be better than mine, but you might need to make it bigger
Okay.
because my screen's pretty small and I'm
Yeah,
struggling.
it's hard to read.
So that's okay. Thank you.
Thanks. Does that look like the section regarding open records compliance?
Yes, at first glance, yes, 6.6, Open Records Act compliance.
Okay. And it says that all open records requests submitted by members of the public will be handled by the open records officer. Is that you?
It will be handled through the portal, so no, not necessary. It will be handled under my leadership.
Okay. And so handled under your leadership, but through the portal. It also says that DA employees should consider all communications that occur on county email, cell phones, and other county-owned technology to be considered open to a FOIA request.
Subject to no exemptions, yes. So I think that's consistent with the Open Record Act. I would
Okay.
agree with you.
Okay, so subject to no exemptions, county email and cell phone communications would be something that you would provide in open records.
General rule, but I think you and I can agree certain things exception. I work with 385 staff members. Of those 385, about 150 or so
Okay.
are attorneys, and we know that there's exemptions. So anything that they're working on as it relates to attorney work product or confidentiality work product are exempt. So yes, this is the general rule, but I don't want the general rule to be mistaken as the norm.
Right, I understand. Definitely, there's statutory exemptions.
You and I are on the same page.
The statute's the
And to be
statute.
clear, the employee handbook, while it is helpful guidance, doesn't change what the statutory obligation is one way or the other. So
No, it just, and the reason I'm asking him is the process in their office to try and understand this process.
And if I can clarify, I think the second sentence is certainly important, right? I know that our employees, again, I alluded to the size of the office, 385 approximately. We want to make sure that staff members who receive open records requests know what to do with it. So that I think that was the angle.
Okay, so the employees receive this and they are told that they need to forward it to legal counsel of the district attorney when they get something.
At the time of that writing, yes, legal counsel.
Okay, this is the current handbook though, right? I'll represent it's the one that your office provided earlier this week through Ms. Monroe.
I would say yes. If your representation is correct, I would take that as this is the current one.
And legal counsel, right now it's Ms. Abbasi, I don't want to say her name wrong.
Alabi.
Miss Alabi is legal counsel now. It was Mr. Armstrong before, correct?
Yes, he was at one point.
Okay, so according to this, Mr. Armstrong or Ms. Alabi would be copied on all open records requests received by employees?
So no, let me deviate. The answer to that is no. The reason why is we had several different legal counsels since 2021, and based on their strengths, weaknesses, or expertise would determine whether or not legal counsel will handle that. I had legal counsel before. That was his expertise. He felt comfortable handling it. I cannot say if Kevin Armstrong handled open records. So I want to be clear. As it relates to Andrea Alabi, a dynamic attorney, however, open records is not something that she handles.
So if a member of the public was reading this and at the time they made their request, Kevin Armstrong was legal counsel, it'd be reasonable for them to think that Kevin Armstrong would be apprised of their open records requests, assuming this is followed.
No.
No.
No, I don't think so.
Okay. This also, let's see, if we go down a little bit more, it talks about emails. Let's see, email communications. This advises employees that emails are monitored, and essentially that means that you're telling them you have access to emails, or the office has access to emails, correct?
You have to tell me the line. The way that I read that is my district attorney, Fani Willis, requires us to look at emails. So 3 times a day is our standard.
If you look under section 6.9, the third line, it says to ensure compliance with this policy, computer and email usage may be monitored. Does that mean that the district attorney's office can monitor computers and emails?
Not necessarily. Well, can we? Yes.
Can. That was the question.
Yes.
Okay. So you have access to emails?
Yes. I do have some. Let's be clear.
Some
emails. Yes.
Access to county files on county computers or county phones?
Yes.
Okay. So on a county computer file email system, you've got access to emails.
When you say you,
your office, I'm sorry.
Okay.
I mean, when I say you, it's been represented, and we can pick a term if you want, but as that you're the man for open records. You're in charge of all of this. So
the answer to your question is, as in you, as in Dexter, right? Yes, I will have access to that.
Okay.
Or I will request access. Is that better?
Yes.
Okay.
And so this also, if you look at, let's see, after where it says only those who are directly supervised by the district attorney can send emails directly to her. So is that the policy that someone who's not supervised by her is not permitted to send emails directly to her?
We have a strict chain of command, so I think that is true.
Okay, so it's reasonable then for a member of the public who is trying to seek emails to assume that emails would go through a supervisor before they went to the district attorney.
That'll be a general practice. I think so.
As an open records custodian, part of your job is to be familiar with the rules with record retention, right?
Yes, to a degree.
Okay, and so you've got to, and that's actually in the, if you look on the same page, if you go up a little bit, there's a policy for record retention, and it says that all records are maintained in compliance with the state of Georgia's retention schedule. Would you agree with that as the policy of your office?
That is the policy.
Okay. So any records that the public is trying to access, they can assume based on the policy of the office that you're going to retain them based on the state of Georgia's retention policies.
That is an accurate assumption based on this policy.
Okay. While we're on this document, if you flip to the next page, 0603, it talks about county cell phone policy. it says that all investigators and attorneys are required to have a county cell phone, and that text messages, recordings, and photos within that cell phone are the property of the county. So that means that if someone did an open records request for those types of documents, that's in the county's property, right?
This is what get hairy. As it relates to Fulton County's property, the answer is yes.
So it says they're required to have a county cell phone. So an attorney is required to have a county cell phone. Let's use an example. Jeff DeSantis is required to have a cell phone, county cell phone, correct?
He doesn't work as an attorney in my office. If we're going through your analogy, give me an attorney. I can't speak for Jeff.
And I'm looking, it just says all investigators and attorneys.
And Jeff isn't an attorney.
He's not an attorney?
I don't, in the capacity of my office, no, he doesn't act as an attorney.
So
ADA, yes, is required to have a cell phone. An investigator.
Jeff DeSantis doesn't have a county cell phone?
No, I'm not saying that. You presented the analogy that all investigators and attorneys are. I understood your analogy. You gave an example of Jeff DeSantis. If your analogy is investigators and attorneys, I want to keep you honest.
Jeff DeSantis is required to have a cell phone, county cell phone, correct?
And I'm letting you know that in the capacity of Jeff DeSantis, he doesn't fall in either category. So I'm following you, and I offered you an opportunity to present someone else, and I gave you an idea of an ADA because the ADA fits with your example.
Let's back up for a second.
Okay.
Jeff DeSantis, and I was just using him as an apparently unfortunate example. He is the deputy district attorney, correct?
Mr. Bond Jr., quite frankly, is the one who has the information.
His working title in the office is public relations.
May I approach the witness, Judge?
Sure.
Thanks. Showing you a printout of the district attorney's website. Can you take a look at that and see if that refreshes your memory as to what Jeff DeSantis' official title is within your office?
Deputy district attorney.
Thank you.
Overseeing the media relations unit.
So the policy that we're looking at, county cell phone, says all investigators and attorneys are required to have a county cell phone. You're saying that not all attorneys and investigators are required to have a county cell phone. Is that accurate?
That's not what I'm saying. You gave me an example of Jeff DeSantis. I could not speak specifically as it relates to Jeff DeSantis. I'm not arguing whether or not this policy exists. All investigators and attorneys are required to have a cell phone.
Okay.
That is correct.
Okay, so all unnamed attorney has a cell phone. According to this policy, if that unnamed attorney on their county cell phone is messaging on an app on their county cell phone, and they're recording things, and they're taking photos, screenshots from an app, that's subject to the open records request.
If there's no exceptions, yes.
If there's no exceptions, thank you. Okay, let's move on to one of the requests that I want to talk about, and I have a couple different identifiers if you need them, but it's the critical mention media monitor. Oh, do you know if Jeff DeSantis has a county cell phone?
No, I do not know that.
You do not know that. Okay. Who would know that? I'm assuming him. Anyone else?
I don't know.
Okay. All right. So let's move on to critical mention media monitoring. If you need me to tell you the request, the open records number request or our exhibits or anything, I'm happy to do that. Just let me know. Okay. But I'm going to globally refer to them as critical mention media monitoring.
Okay. I'm going to stop you here. I know that we have a lot of critical mentions. So I would prefer for the clarity of this court to make sure that we're specific on critical mention because I know there's multiple.
Not a problem.
So
there are two.
So my ask is don't globally refer to them as critical mention, if that's okay with you. Okay.
Can you pull up merchant 0027, please? There are two requests. This one, just for your clarification, ends in 010924. This is my first open records request. On January 9th, I requested any and all correspondence, as you can see, to or from critical mention, including copies of contracts, payments, analytics, reports to or from critical mention in any member of the district attorney's office. Would you agree this request is pretty clear and concise?
Based on my reading, yes.
And I submitted it through the Fulton County Open Records portal.
January 9th, yes.
And it was received January 9th. It says, if you scroll down a little, it shows it was received that day. That's when they return it with the reference number, that is saying that it was received.
That is correct.
Can you repeat what page you were referencing?
I'm
Ms. Mercer?
so sorry. Yes, it is a merchant 0027, and it acknowledges receipt of the open records request, correct?
On January 9th, I received that via the portal. We acknowledge receipt because you have a reference number. The answer is yes.
Okay. It doesn't say anything about whether responsive records exist.
Not on January 9th. That's the day I received it.
Doesn't say anything about proposed costs or when the records will be made available.
On January 9th, when I accepted it,
Mhm.
no, I think that you have requested several open records requests. You have given them, you've been given all the records, right, that we closed out free of charge. So there is not anything that from my office that would have a cost, because I did not charge you on any open records request that you provided.
I didn't ask that. I asked if it provided any proposed costs. Does this provide any proposed costs?
On January 9th response,
This document.
this document that you put before me, January 9th, I acknowledge that it is a receipt number for tracking purposes. It is a acknowledgement of receipt, and is a description of the records you requested.
Great. If you would scroll up, so on January 12th, someone wrote back, or I wrote, thank you, and I followed up saying I was asking for the analytics, the contract, and the analytical reports. And I was asking, following up, when I could receive them.
3 days later, yes, it appears, I don't know, Ashley Merchant wrote, thank you, in follow-up. I also asked for, yes.
Okay. And then on January 11th, someone, either from your office or the county, said, please log into the portal and see attached emails, correct?
January 18th.
January 18th, I'm sorry, if I said a different date.
So January 18th, based on this email,
Okay.
we gave you attached emails, and included in those emails, there were several different documents. So yes, I responded to this open records request on January 18th.
Did you type this or did someone else? Please log into the portal.
I did not type that.
The attached emails, did you provide those attached emails?
No, I did not.
Who provided those attached emails?
A member of my staff.
Who?
A member of my staff. I do not know who provided that on January 18th, but I do know that this particular request, as you said, was pretty straightforward. So we responded and it was closed out. This wasn't elevated to me.
So you never saw this request? You were not involved in this request at all?
On this particular request based on the portal, I don't recall this being elevated to me on January 18th. No.
So you can't tell us what searches you performed looking for these documents?
I can tell you that.
You can.
Yes, this was a general request. It wasn't elevated to me. Critical mention is something that was always asked. I have several requests that's very similar to this. So I'm pretty sure that not this particular one, but one of critical mention was elevated to me, and we responded the same way we did with most critical mention.
Who did you ask?
I'm sorry?
Who did you ask in response? You said you did ask somebody about these records. Who did you ask?
So with critical mention, you ask, based on this search, you will look and you will reach out to Jeff DeSantis.
I would still object to Mr. DeSantis being called as a witness for the same argument that I've made a couple of times now. He is just, he does not have any relevant information concerning anything that has been before your honor.
Hey, do you have any emails related to critical mention? After that, you will go to the IT department to confirm.
Okay.
See if there are any responsive records.
Fulton County IT department.
Yes.
Okay. So Jeff DeSantis and Fulton County IT are the two. Okay.
Especially when you ask it for emails, the answer is yes.
But you don't know if you did that in this case.
I know that I did that in critical mention. I have 1,000 cases. So as it relates to this specific request, I cannot tell you that this particular case was elevated and it was on the top of my list.
And once someone makes a request like this, what steps do you take to ensure that the documents they're requesting are preserved?
Repeat that?
When someone makes a records request like this, as an example, what steps do you take as the records custodian to ensure that the documents they're requesting are preserved?
They are placed in a portal Once the portal is sent to you, I think that you have access to that. And I think that that is something that the portal does and make sure that it is reserved. And I can have a copy if I needed to go back to those specific documents. So as it relates to you, this is when you and I are going to make sure we're not splitting the baby. But as it relates to the portal, they are reserved.
Okay. And we'll use this as an example and sort of walk through the request. So once you get a request like this, whether it's elevated or not, what are the steps your office takes to make sure that the documents I'm requesting aren't destroyed?
Typically, once documents that you're requested are placed in the portal, right, will maintain those particular documents, right? You have an email version, electronic file of those versions. So that's in the portal. So
and maybe I wasn't clear. So you're telling me how you maintain the documents you give me. What I'm asking you is when I ask for critical mention documents here, okay? And you get this request and you give me some of them. How do you make sure that they're all maintained? So where do you all maintain them? I'm
going to answer your question, but I'm going to make an assumption if I may, okay? I made a comment and I said that there was 40 open records requests. You looked and it appeared, assumption, emphasis on assumption that you was going to go see how many open records requests you had, right?
It's all there.
Yeah. So the answer to your question is it's in the portal, it's all there.
No, that's why I didn't know if you understood my question. My question is not.
I just repeated you.
Hang on, don't talk over each other because the court reporter can't take it down.
My apologies.
That's okay. Ask your question and then you are free to respond in any way you wish.
I'm not asking how you preserve what you tell me you have. What I'm asking is how you preserve the documents inside of your office that I request, not the ones you give me, but the ones I've asked for.
If you ask for 5 invoices, right? I'll take those 5 invoices. Those 5 invoices is giving to a staff member to provide to you. So the original copy of those invoices maintain wherever they are, right? You have a copy that's filed electronically, right? It is given into the portal. So if I understand your question correctly, 5 invoices. The 5 of those invoices are sent to someone on my staff. A copy of those invoices are uploaded to the portal. Those 5 invoices, the original copies, wherever you came from, continue to stay there. Did I answer your question?
Yes.
Okay.
So the originals continue to remain wherever they originally were.
It depends on the particular document. If you, in my example, I gave you invoices.
Right.
We do know that invoices are electronic, right? Well, I like to think that most invoices are electronic. So in those particular invoices, wherever they are on my particular file, they stay. A copy is employed to my staff member and then uploaded to the portal.
And let's go through some specific things that you gave me, and then we can sort of go back to that question because it might help. If you look, let's see, if you can pull up merchant 0029, on January 18th, there was, let's see, I received this packet that we talked about of emails uploaded to the portal. What you're looking at is the beginning of that packet, and it was 44 pages. That was in response to my original request discussing critical mention. You said you did not produce this document, correct?
No, I don't believe so.
Did you assist in retrieving these documents?
For these particular documents, no. These documents appear to be responsive to your open records request. It appears to be delivered to you on January 18th, and it appears to be responsive to your request.
You can look at 0055. If you go down a little on this one, see where it's after Melissa Fritz, it says Fani Willis critical mention search. It's a different font, and then PR value for the week. And then there's a couple other things. This, and we now know, because we have the actual emails, we now know this is 4 or 5 different emails that were pieced together. Did you participate in the cutting and pasting of these documents into one?
Objection, Your Honor.
I don't.
Objection, Your Honor. It presumes that he cut and paste documents, and that was never established by his testimony. So we're objecting to that.
Okay, well,
question.
for now, I'm going to sustain your objection to the characterization of the cutting and pasting. But you can certainly ask him if he participated in the creation or generation of this document that was produced to you, however it came to exist. So your objection is sustained to that extent, Ms. Monroe.
Mr. Bowman's witness, I might be mistaken, but I'd prefer not to tag team.
Well, I do agree. I apologize. Who is going to be examining this witness?
I will be.
Oh, okay. Well, then fair enough.
I didn't know that was a thing.
Well, I mean, generally, had objected, so.
Yeah, generally speaking, you know, whoever's going to be examining the witness is the one who should be controlling the objections. And I think Ms. Merchant's expressed concern was she thought Mr. Bowman was going to question this witness, which would make your objection problematic. But since you're going to be examining the witness, it's fine.
That's fine.
I'll refrain further, Your Honor.
Well, usually I just ask that you whisper in your partner's ear so they can then say the thing that you want them to say.
And I showed Mr. Bowman the documents because he had made the first objection, so I just was assuming that was the path, but I will shift. Okay, so this document, however it was created, did you assist in the creation of this page?
No, I think you and I agree that the first request was straightforward. I don't think that this was elevated to me. And on January 18th, no, it was not elevated to me.
Who compiled the document in the form that we see it in here today?
A member of my staff. That's an assumption. A member of my staff.
Okay, so you're assuming, but you don't know who compiled this.
Specifically,
yes,
on January 18th. Yes, this is a designated employee. Yes.
You're positive it's a designated employee?
Well, okay. Yes, I'm positive I know who that is.
Who is it?
Erica Willingham.
Erica Willingham. So Erica Willingham is who we would need to ask, not you as the records custodian, about how this document was created.
I cannot answer that question. Let me explain why, right? Typically, emails are compiled in a certain kind of way, right? And those emails are compiled by IT, by staff. It may be compiled by going to reach out to various different persons. I cannot speak to that. So I cannot tell you if she personally, if the question was, did she compile? I do not know.
Mr. Bond Jr., quite frankly, is the one who has the information.
I do know that she handled it as a member of my staff. I do know that she responded as a member of my staff. I can tell you that.
Okay. So you can't say as the records custodian that this is an accurate copy of an original document. Let's put it that way. You really don't know anything about this document.
I do know something. I know it was responsive to your request. So yes, I know something. I think you and I can agree on that.
Okay. Let's take a look at, I'm going to jump out of order. I apologize. If you, let's see.
I also know, if I may, that it was provided to you on January 18th. I also know that you received this particular document on January 18th. I also know, as you mentioned, that there was a second critical mention document. And in that second critical mention, I know you referenced this before, right? I also know that once you referenced this before, you renewed a second critical mention document saying, hey, you gave me this on January 18th. I'm looking for A,
yes,
right?
And
that's why you and I on the same page, didn't want it to be global. So I do know information as it relates to this particular request.
And we can actually go there right now. So I filed a second request because my initial request was closed when you all provided this 44-page document, right?
Yes, on January 18th, it was closed.
And so on January 18th, I refiled my request and I specifically referenced the original one and said, why are you closing this? You didn't give me everything.
If I can,
yes.
I like the fact that you presented the first one and allowed me to read it. Can I read the second one?
Of course, it is. Let's see. Have the number off. Second one is Merchant 0011. Might take a minute. Oh, doesn't take a minute. There we go. So this one, I said in regards to my prior request, and I referenced that number we just talked about, and I said I requested the critical mention documents, and I say the number. I said I got a set of emails, but I asked for the analytics and the documents that are clearly referenced and attached to those emails. I said reports with analytics were provided to the DA's office monthly. It appears from the emails that Jeff DeSantis, Fani Willis, Jeremy Murray, Pallavi Perkasa, Robin Bryant, and Rita Kepler may all have access to these reports on a regular basis. They're public media, paid for by public funds and subject to open records.
Yes, I did receive that. This was elevated to me. And I did respond to you.
Okay, so this one was elevated to you, and you definitely did respond. Before we get there, let's talk about what we were just talking about a minute ago about I don't want to use the word cut and paste, the document, and I'm going to call it Merchant 55, that appears to have a compilation of several other emails contained within it. Okay, that document we were looking at a minute before, and you said you don't know who prepared that document, right?
I do not know who compiled that. I know who handled the file. I know who sent you the responsive documents.
And you don't know where that person got the responsive documents, but you assume it was Jeff DeSantis, is what you said earlier.
I did not say that, ma'am. I'm sorry?
Who did you ask in response? You said you did ask somebody about these records. Who did you ask?
So with critical mention, you asked, based on this search, you will look and you will reach out to Jeff DeSantis.
You said you would reach out to Jeff DeSantis in Fulton County IT.
But he certainly wouldn't compile any documents for me.
Oh, okay.
Okay.
So who would compile them? Who would, and let's just look then. So you've seen, and can you show him again, Merchant 0055, just take a look at this document, because I'm gonna ask you to compare it to a different one.
Okay.
So just to make sure I'm clear, I thought that Mr. Bond said that he believed that Erica Willingham is the person who compiled the response at Merchant 0055.
I thought he said that she did, but that she would reach out to Jeff DeSantis and the count. First, he said he didn't know who provided it. He said that they would reach out to Jeff DeSantis and Fulton County IT.
Well,
and then later,
that's actually why I'm asking for clarification, to make sure we're all having the same conversation, because I understood you to be asking him about who compiled the document that was provided to you, not who obtained the information that was then determined to be responsive and compiled into a document that was provided to you. What I understood Mr. Bond to be saying was, this type of request, I would have reached out to DeSantis and maybe County IT, and then it was compiled by this particular employee and provided to you.
and I'm not sure. That's the ultimate question. So let me try and be a little more clear then. This document, number 55, okay? It looks as though it's a compilation of other emails, okay? If you look after Melissa Frick's name, it says Fani Willis critical mention search, and then PR value for last week, and then there's that middle section that we're talking about. Middle section right here. There's no header to from or dates here. There's no header to from dates here. There's no header to from dates there. That, they all look like different emails, right?
I would agree with you.
Okay, so not using the word cut and paste, someone took these parts and put them all in one.
Objection, Your Honor. Is that a question? Is a statement? I mean, if it's a question to the.
Well, he's an adverse witness, so she can cross-examine if she wants to, number one. Number two, I mean, the reason I said we were not going to call it a cut and paste is that assumes facts that are not yet in evidence. Now, you can ask questions about assumptions that you're drawing from the appearance of the document, but that's why I've said we're not going to call it a cut and paste. Now, I think the witness has called it a compilation, so why don't we call it that for a while until we decide that it's something else.
So this appears to be a compilation of several different emails into one.
I agree. Compilation, yes.
Okay.
And go ahead.
No, that's okay. Continue. We're here to learn from you. Tell us. What were you going to say?
No, I'm agreeing with you. That does appear to be a compilation of emails.
Okay. And can you pull up Merchant 0167? So there's a redacted section here, and then you can see under that, I sent a story via critical mention a few minutes ago, direct link below. Okay. So this, and this were removed from that email. It just starts with, I sent a story via critical mention. All of that is not in that compilation document, right?
As it relates to the headers.
As it relates to the, I'm sorry?
Yes.
Yes.
It does not appear to be so.
So this was all removed. and the document just starts right there.
I cannot tell you if it was removed. I think my testimony, Your Honor, is that this particular request came in January 8th, right? We responded on January 9th. On January 18th, we responded to the documents, right? Once we responded to the documents, you accepted it. What I need you to hear is we closed that particular file. It was not elevated to me. Your second one was elevated to me. Let's call that critical mention 2, if I may. That critical mention 2 referenced the first critical mention, right? In that critical mention 2 that you just displayed to me, it had only one specific item. I am looking for analytical graphs. I responded to that request. So as it relates to anything that from the first time I gave it to you, it was responsive because this is me as the business record custodian. Once I received the second critical mention reference that referred to the first, you and I can agree that the first had, let's just say, 5 things. You only made mention of one thing in the second one. I assumed 1, 2, 3, 4 was resolved, that is closed, and I responded on January 26th to the remaining issue. So as it relates to compilation, I want to be very clear. It was sent to you. It was responsive to your request. I moved on. You referenced it. Once you referenced it, it was elevated to me. The elevation was one specific item. So I assumed that the first matter was resolved and the only outstanding issue related was analytical drafts embedded into something, which I responded to you on January 26th. Is that clear?
This is the one who has the knowledge of how open records work within the office.
No.
Okay.
And so let me break it up because there was a lot. So I tried to take notes. First, you said I accepted it. So on January, whatever the date was, 18th, I accepted it. When you said I accepted it, you sent me a document and I accessed it and it was immediately closed. So you're saying that's an acceptance of the open records response?
I am saying that we sent you the open records response that's responsive to your request.
Yes.
All right. I am also saying that you opened up another open records request. In your second open records request, that's why it's very important. We do not refer to this as globally. You make reference to the first.
Yes.
You said here in court that the first one was very detailed, in which I agreed. Okay. I let you know that I did not have anything to do with that. You gave responsive records. Once you respond to me in reference to the first one, and there is one thing outside, I am a reasonable person, that's a word that you use, will assume that the first is over. It's done. It's complete. So I am assuming, reasonable or not, that you accepted the open records request because you said, here's a second one. I did this, I'm referencing that, and here's a small section.
So you assumed I accepted it and
It was delivered.
Hold on.
Is that better?
Deliberate.
It was sent to you on January 18th.
Yes.
Y'all, there is no reason to argue about the semantics of what we're talking about. It is not in dispute that on the whatever day it is that the Open Records Act portal sent you a batch of documents. And then I don't think it's in dispute that that request was closed and then you followed up on it, which the county or the Fulton County, whatever we want to call it, treated as a new request that referenced a prior request. We don't have to argue about whether it was accepted or received or acknowledged or whatever. The facts are what happened. Let's move on.
Thank you.
So you said that it was that was responsive to my request, but it didn't completely respond. It only partially responded to my request, the first one. The 34 pages weren't all that you had.
Objection, Your Honor. Is that a question or a statement?
It's a question. The 44 pages.
Hang on. When there's an objection, let me deal with it. We're just going to put a question mark on the end of Ms. Merchant's statements because technically that's what they are, but they are allowable cross-examination questions. So
Right, but I want to put the witness in the best position to answer the question. So if it's not posed in the form of a question, I think that's the onus is on her to pose it in the form of a question as opposed to a statement.
I think that right now I'm gonna, unless I believe that it's being deliberately confusing, which so far it is not, I'm going to allow Ms. Merchant to question the witness. And I'm gonna overrule your objection for now. Go ahead.
Thank you.
You have to repeat your question. I'm sorry.
The 44 pages that you sent me on January 18th, you said that they were responsive to my request, but they were not complete. There were additional documents. Now we have 197 pages. So the 44 were only partially responsive. Is that correct?
Okay, I have issue with your question, so let me break that down, okay? As it relates to you, I have testified that on January 18th, a member of my staff responded to you and provided you responsive documents, okay? So you as in Dexter Bond did not give you anything, okay, on January 18th. The responsive request for your records that sought 5 things were given to you on January 18th. The answer is yes. On the next day, as you just testified, a new open request was open. You made reference to the first request, right? Of that, again, the first request was 5 things. You only asked about 1 thing. The first one was never elevated to me, okay? The second one I responded to on January 26th.
Okay. So my question didn't answer my question. The 44 pages that you provide, that your office provided on January 18th, that is not all the documents that were responsive to the original request. It was only partially what was responsive. Correct.
At the time on January 19th, I couldn't answer that question. I don't know. I don't know.
So you gave me document, or your office gave me documents, and then you have now certified 10 days ago that 197 pages are the actual.
2 different things.
Yes.
So I'm glad that we was able to
Hold
talk.
on. So now we've got 197 documents.
Okay.
Back then we had 44.
Let me,
Okay, hold on. Those 197 page documents, those existed in January when I made my request, correct?
I cannot say that.
You don't know if they existed?
May I respond?
If you answer my question first, I'm happy to allow you however much time you want to respond.
Okay.
Did those documents exist in January? The 197 pages? Your business record certificate?
I cannot answer that question. May I explain?
Why you can't answer it?
He is the best witness. He is, quite frankly, the only witness that can really testify to the mechanisms that we have in place within the office.
No, let me explain why I cannot answer it. That's correct. Let me explain. Your open records request as you presented asks for certain things, right? I'm assuming that you are talking about the production of documents that you gave on August 30th, right?
Yes.
All right. And you, in that production of document, I'm assuming you're saying that that was 197. What I am saying that I cannot correspond because it's my assertion that the open records request that you received on January 18th is different in scope from the subpoena you requested. And because there is a difference in scope, because your subpoena was more specific, I cannot tell you if the two are correlated. So I cannot answer your question.
So you can't tell me if the 197 pages that you provided on August 30th, if those existed in January?
Yes, they would have existed. The 197 pages should have existed. However, I cannot tell you, let me be very clear, that the 197 pages that you received on August 30th as a response to your subpoena was responsive and should have been included in the 44. I'm afraid that you are looking at an open records request that you received on January 18th, accepted with no reservation. You're convoluting a subpoena. There's 2 different scopes. There's 2 different, your search terms were different. So yes, the 197 did exist in January 18th because the scope in which you asked for was from January 2021 to the present, whenever the subpoena came in, right? We did that through IT. Those documents could certify. I cannot tell you if those 197 were responsive to the 44 because your open records requests and your subpoena are different. Your subpoena is more specific.
Okay. So my open record, my first one said that I was seeking a copy of any and all correspondence to or from critical mention, copies of contracts, payments, analytics, and reports. Okay, so correspondence, that's emails.
One.
Correspondence is emails.
And I gave you emails.
The 44 pages versus the 197 pages. Would you agree with me that there are a lot of emails in the 197 pages that were not contained in the 44 pages? A lot of emails. We can go through them page by page if you'd like.
If that's what you prefer.
It is not. It's
Okay.
definitely not.
What I am telling you, and I need to be very clear, that your subpoena that produced 197 pages, right? It required, look at this particular email to and from, right? As it relates to these particular search terms. So your subpoena was filled out and given to the Fulton County IT department, and those 197 pages were given, researched, and provided. Let's look back at your open records request. There were no search terms. If I am not mistaken, and you may have to bring it up to reflect my memory, you just wanted something about to and from the vendor or something like that. There are two different things, two different scope. So if you're making an inference of 44 versus 197, I cannot buy into that inference because I see logically why 197 and 44 could be different.
And I'm trying to break it down simply so that we can just get through one item at a time. My original open records request, we're only talking about correspondence. You and I agree correspondence includes emails, correct?
I agree.
Okay. And would you agree that the 44 pages did not contain a lot of emails that the 197 contained?
I can concede that.
Okay. The next classification is contracts. Okay, so I asked for contracts between the DA and critical mention. Okay, would you concede that the contracts I got in the 44 pages with my open records request did not contain all of the contracts I got in the 197 pages? Would you concede that?
No, I cannot concede that. You have to show me that.
Okay, that's not a problem.
You
Which
have
one?
to show me that.
So we'll break it down even further. In the 44 pages, the original request, you only gave me a contract for the first year of critical mention, correct?
Show me.
Okay, let's see. Okay, the 44 pages start at, just so everyone knows, they start at merchant 0027. And that one may take a few more minutes to get up because we didn't have that one queued. Oh yeah, 0027. And if you want a hard copy of the documents, I can give you that as well. Okay, in response to that, if you go through the next couple of pages, is it easy to pull up the next couple of pages? Yeah, let me give you the exact page. It's actually the next page, 0028. That's the February 2021 contract for critical mention. Oh, there we go.
I'm glad you said that. I'm glad you showed me this isn't a contract.
No, this is not. This is part of it. And if you go through.
You and I just had a conversation about emails. I conceded. Now you're talking about contracts. I told you to show me. Now you show me an invoice. Which is it? Do you have a contract?
Judge, I mean, I don't care if he asks me questions, but I don't really think it's appropriate if he asks me questions.
Well, I'm not, you're not obligated to answer the questions he asks you. I would just encourage everybody to try and maintain a tone of civility and let's move on.
Yes, Your Honor.
So we'll back up. The 44 pages. I'm going to give you the 44 pages. Okay. So you can just look at those. We don't have to go.
Are you going to point out the contract in the 44?
Give me 1 second.
Oh, okay.
Okay.
I'm sorry.
So my open records request to you asked for contracts. Okay. That was one of the classifications we just talked about, right?
Yes.
Okay. Show me where in there you gave me contracts.
I did. I don't believe it's in here. You could not show me. So do you want me to go page by page? Because you said that you was going to show me. You gave me an invoice, right? Okay. And then I said, all right, the 44. So now I can go through here to determine a contract. So you put, I'll do it. So you said that you was going to show me.
I'm going to show you the one you gave me.
Okay, no.
But that's in the second request.
You're talking in the context of these 44 pages. You told this court that I gave you a contract. I said, show me. You approached me with the invoice.
You gave me that invoice.
Okay, stop. Both of you. The question I think is pending that will actually help us move forward is that Ms. Merchant asked if any contracts were produced in the original 44-page production.
Yes.
And while none of us will necessarily enjoy that endeavor, it is perfectly fair for a witness to say, let me review the 44 pages and then I'll answer your question. And so if you would like to do that, you feel free to do that. But the question is,
Thank you.
was a contract produced in the initial production of 44 pages? Because I think we had agreed that contracts were requested.
Yes.
Okay. Go ahead. Mr. Bond, if you want to go through the documents or if you want Ms. Merchant to direct your attention to something, we can do that. But the 44 pages is entirely fair for you to say, let me look at these documents before I answer your question.
Yes, I would like for you to direct my attention as you said you could.
I'm asking you to answer the question the judge just asked you that I originally asked you. That I asked you if you gave me a contract in January. We agreed that I asked for a contract, okay? So we agreed I asked for a contract. I want you to show me where you gave me a contract. Or if you didn't, tell me you didn't.
Okay, allow me to review.
Great.
Based on what you presented to me, assuming that there are 44 pages here, no, a contract is not in this.
Okay. In the 197-page document that has your sworn certificate on it, did you provide me with a contract?
May you direct me to that contract?
I'll give you the whole 197 pages. It's your sworn business record certificate that you swore to the court was accurate and complete. Give me a moment to reorganize. Let's see. Would you prefer it on the screen or in person?
In person, please.
I'm going to give you one of them as an example. May I approach, Judge?
Yes, and you don't have to ask every time.
Thank you. Call the renewal of work to that.
Ms. Merchant, I'm sorry, I can't hear you when you step away from the podium very well.
Sorry, thank you for reminding me of that.
The renewal statement of work, if this is in my file, here you are, but this is a contract.
It is. Okay, so what I just showed you was the contract, one of the contracts for critical mention, correct?
You showed me a renewal statement of work.
And that was not provided in January of 2024, correct?
It does not appear to be so.
Okay. I'm going to show you another, the microphone, sorry.
And if I can, before I know you're about to move on,
I'm not.
we agree, right, that there were some emails, right? We also, as it relates to the contract, you said that you that there was some documents in that particular file that you have in the 197, okay? You also can agree, I hope, that on the second open records request, you brought forth, that was elevated to me, hey, Dexter Bond, I'm only missing with the analytical. So you and I can agree that any contract or anything was not in your any open records request. We can agree to that?
No, we cannot. Can you pull up merchant 0055, please? Oh, I'm sorry, wrong one. We just had it up. I'm sorry, 0008. I am seeking a copy of any and all, including copies of all contracts. That is my original request.
Yes, but you and I, you received this on January 18th. Yes. On January 19th, you said, you referenced this same open records request, right? And you said, I am only looking for, I received your request, you acknowledge receipt. I am looking for the analytics inside that.
I'm not talking about that yet, and we're gonna be here all day if we go and talk off track. The first open records request, this one, first one, I asked for contracts, okay? I just showed you a contract that you gave me on August 30th. That contract was not provided in response to this open records request, not a follow-up, in response to this open records request, correct?
The answer is yes. That contract was not provided in January 18th.
And here's a contract mentioned for 2021 to 2022. You take a look at that.
Yes.
That contract was provided August 30th, but was not provided in response to my open records.
This statement of work appears to be provided in August 30th.
I mean, you certified the documents that you provided August 30th. Do you have any question about them?
No, I certified the documents on August 30th, but what I need to be clear is once the matter on January 18th was not elevated to me. I think that we're clear on that. When it came to January 26th, you requested 5 things. There was one thing in your second open records request that you brought to my attention. That was elevated to me. I assumed that on the 44 pages, everything else was responsive because you do a good job when you don't get something, bringing it to our attention. We do a good job of responding to you. So yes, you asked for 5 things on January 18th. My staff gave you 44 pages. When you brought forth the second critical mention open records request, of those 5 things, you brought forth 1. That one thing was elevated to me. So we make mistakes. If I did not give you a contract on January 18th, I would have loved, as I often hear from you, to get, hey, you're missing this. Just like you did on the critical mention analytics graph, you did not bring that up.
Judge, this is not responsive to my questions. I mean, at all, not even close to responsive.
He will testify.
Okay.
Yeah.
I generally try to let the witness answer the way that the witness wants to answer. I will, however, say that I think we are getting bogged down in what previously did or didn't happen based on people's characterizations and understandings rather than, and I think one thing that would help, Ms. Merchant, is if you would ask short, clear, direct, factually based, and not argumentative questions. And then Mr. Bond will do his best to give short, concise, factually based responses that are not argumentative, because I understand that both of you have a position that you wish to vindicate about what you did or what you think did or did not happen here, but we need to set that aside. Go ahead, Ms. Merchant.
Just asking you about my first request. We're on to the third category, payments. I asked for payments. How critical mention was paid, correct?
You asked for contracts and or payments on January 18th.
In this open records response, did you give me payments for critical mention?
I gave you 44 documents that I believe was completely responsive to your request.
Mr. Bond, you did not give me a copy of the payments for critical mention.
And when I reviewed the 44, I did not see a payment.
And you also did not give me any analytics, correct? In response to this one, just this one.
On January 18th, no, I do not believe. When you say analytics, I don't even know what you're talking about. Are you talking about the graphs that's embedded in the critical mention? I don't know what you mean by analytics. Let me make sure I'm clear.
The critical mention analytics reports.
The same analytics reports that you asked for in the second critical mention request?
I'm only asking you about the first one.
So no, the answer is no, not in January 18th.
Reports in response to this request.
The answer is no.
So the 5 categories, correspondence emails, contracts, payments, analytics, and reports. You did not give me any of those 5.
I gave you 44 pages.
So now we move to the second request. So when I got those 44 pages and was not happy with the response, I filed a follow-up open records request. Do you remember that?
Hang on, Ms. Merchant, to my point about argumentative, right? this is further complicated by the fact that you're also your own witness. And so your questions are not only tending to be argumentative, but filled with facts that haven't been established yet. So,
okay, and that was
on that.
and I was drawing from what he said about me.
In reference to the document, I think that'll be a cleaner way to keep the record clear. That way we know it's a fact that's in the record.
That same day, January 18th, now I'm talking about that second open records request. I followed up and asked for more documents, correct? I'm just asking if I followed up and asked for more documents. I'm just asking if I followed up and asked for more documents.
May I answer this question this way? You pointed out the 5 categories. Thank you for doing that, okay? In your second open records request, you asked for not more, the same documents in one. To me, that was interpreted as you have satisfied my open records request, so I cannot say if you was unhappy. However, of those 5 things, there is one thing in here that you're missing. Can you respond to that one thing?
So let's talk about that second open records request. So I submitted another open records request and asked for more items, correct?
You asked on that second open records request for the analytics graphs that was also asked for in the first open records request.
Okay. And was not provided in the first open records request.
It was not provided, well, based on my review today, no, it was not provided.
And it was also not provided in response to the second open.
So on the second one, a response was provided via the Open Records Act. That response on January 26th, footnote 1 reads, no, on January 26th, I don't know what subsection said. I don't, essentially, forgive me legal terms, I don't know what you're talking about.
Mr. Bond Jr., quite frankly, is the one who has the information.
Your response, your ask is not reasonably calculated to put me, the business record custodian, in a position to know what you're talking about.
He is the best witness. He is, quite frankly, the only witness that can really testify to the mechanisms that we have in place within the office.
At that time, I did not know what analytics graphs were. I didn't know what you were talking about.
Because he is differently situated and he does have information that would be helpful to Your Honor.
So you can reference my letter, which I addressed this second open records request personally because it was elevated to me.
I will in a minute, but let me re-ask my question.
Okay.
Did you provide me any analytics in response to my second open records request?
I provided you a response.
Did you?
In my response, there was.
Hang on. She's asked you a yes or no question. I think you can answer it and then explain.
Yes, ma'am.
Thank you.
No, I did not give you any documents. I don't believe it's in here. You could not show me. So do you want me to go page by page? Because you said that you was going to show me. You approached me with the invoice.
You gave me that invoice.
Okay, stop. Both of you.
I would like for you to direct my attention as you said you could.
I'm asking you to answer the question the judge just asked you that I originally asked you. That I asked you if you gave me a contract in January. In the 197-page document that has your sworn certificate on it, did you provide me with a contract?
May you direct me to that contract?
I'll give you the whole 197 pages. It's your sworn business record certificate that you swore to the court was accurate and complete.
You can agree to that?
No, we cannot. Can you pull up merchant 0055, please?
I assumed, because you do a good job when you don't get something, bringing it to our attention.